Hello, my name's David Williams, Queen's Counsel. I'm a barrister specialising in international family law, practising in London. I'm going to talk about the interface between the Brussels regulation and the 1996 Hague Convention on parental responsibility and the protection of children. The structure of my presentation is going to consist of an introduction to the regulation and to the convention, so that's what I will call them. We'll look at the purpose of them, we will look at the children who should benefit from them, and we will look at the interface between the regulation and the convention before looking at a comparison between the provisions of the regulation and the convention. The presentation should last about 25 minutes or so. The regulation, of course, will be familiar to most. It's Council Regulation EC 2201 of 2003 of the 27th of November 2003 concerning jurisdiction and the recognition and enforcement of judgments in matrimonial matters and matters of parental responsibility, repealing Regulation 1347 of 2000. It is known, somewhat confusingly, by a number of different names depending on who's referring to it. It's sometimes called the New Brussels II Regulation, not very new now, of course, it's dating back to 2003. It's also known as Brussels II bis, Brussels IIa, and Brussels IIr, or Brussels II revised. I shall refer to it as the regulation. In addition to the regulation itself, there is a practice guide published by the Commission which deals with those parts of the regulation which are new, i.e. that they weren't in the Brussels II original regulation. You can obtain information about the regulation as well as course of other areas of European Union law on the Eurolex Europa website or the e-Justice portal. If you search for those on Google, you will get those. The regulation entered into force on the 1st of March 2004, and as a regulation it's of direct effect in member states and prevails over national law to the extent that national law might be in conflict with it. As new member states join the European Union, so they become subject to the regulation. Croatia joined the European Union on the 1st of July of 2013 and is subject to regulation. It has been interpreted by both the European Court of Justice and the Court of Justice of the European Union, as it was subsequently renamed. There have been 11 cases which have come before the Court of Justice since 2005. Almost all of them been on preliminary references, either expedited preliminary references or under the PPU procedure. There is one currently awaiting a hearing, which is a reference from the English Court of Appeal, which deals with questions of interpretation of Articles 12 dealing with prorogation of jurisdiction and Article 15 transfer of jurisdiction. Moving on now to the Convention. Its full name is the Convention of the 19th of October 1996 on jurisdiction, applicable law, recognition, enforcement and cooperation in respect of parental responsibility and measures for the protection of children, commonly known and referred to as the 1996 Child Protection Convention, and I shall refer to it as the Convention. It is supported by the explanatory report by Paul Lagarde, and there is a draft practical handbook published by the Hague Conference on the operation of the Convention. Both of those can be found on the Hague Conference website, hcch.net. In England, the Ministry of Justice has also published a practice guide. The Convention came into effect on the 1st of January 2002 when the third country ratified it. So the first three countries to ratify were Morocco, the Czech Republic and Slovakia. However, its take-up was then very limited until 2010 when the European Union member states began to ratify. At present there are 42 signatory states, 39 members of the Hague Conference and 3 non-members, Armenia, the Dominican Republic and Lesotho, and the Convention has entered into effect in 36 of the member states and all 3 of the non-members. The 3 member states where it has not yet entered into effect are Belgium, Italy and the United States of America. The most recent countries to bring it into force in the course of 2013 were the Russian Federation and Lesotho. Montenegro brought it into force earlier in 2013. So it comes into force when it's ratified by a country. All of the European Union member states, save for Denmark, are subject to Brussels II, to the regulation, and all of the European Union member states have ratified the Convention, except for Italy and Belgium. Neither the regulation or the Convention are retrospective in effect, although there are some complex transitional provisions in the regulation in Chapter 6, but they probably no longer apply given the passage of time. For Convention measures to be enforceable, they must have been taken after the Convention came into effect in both states. So if there's an issue to do with recognition and enforcement of an order in a recent ratification, then it's essential to check the date of the order that is the subject of recognition and enforcement. The purpose of both the regulation and the Convention is not to change the substantive law of member states or signatory states. It is to create a uniform international law of child protection. The regulations and the Convention's functions are to improve the protection of children in international situations by providing the mechanics for an integrated system of cooperation, recognition and enforcement, and a uniform approach to jurisdiction in respect of children. They aim to avoid legal and administrative conflicts and to build the trust and a structure for effective international cooperation in child protection matters between different systems. It's intended that those mechanisms for cooperation, recognition, enforcement, common jurisdictional provisions should reduce delay and uncertainty. The objects of the Convention are explicitly stated to be to determine the state whose authorities have jurisdiction to take measures directed to the protection of the person of a child, to determine which law is to be applied by such authorities in exercising their jurisdiction, to determine the law applicable to parental responsibility, and to provide for recognition and enforcement of measures in relation to children in all contracting states, and to establish such cooperation between the authorities of the contracting states as may be necessary in order to achieve the purposes of the Convention. And that those purposes are almost all applicable to the regulation. The difference between the objects of the regulation is that the regulation, of course, covers the jurisdiction in relation to divorce and separation, which the Convention doesn't seek to achieve, nor does the regulation deal with the issue of applicable law. The children who should benefit from the regulation and the Convention are in particular children who are the subject of international parental disputes over custody or contact. Those who are the subject of international abductions, including in those states who are not able or willing to join the 1980 Hague Child Abduction Convention. Those children who are placed abroad in alternative care arrangements, which do not come within the definition of adoption, and therefore are outside the scope of the 1993 Hague Inter-Country Adoption Convention. So children placed in foster care, in kafala, the Islamic equivalent, rough equivalent of adoption foster care, and in some cases placements within families. It also aims to protect children who are the subject of cross-border trafficking and other forms of exploitation, and refugees and unaccompanied minors. So, how do the regulation and the convention fit together? Article 61 of the regulation gives it primacy over the convention where the child is habitually resident in a member state, or where recognition or enforcement of an order of a member state is sought in another member state, even if the child is habitually resident in a third state, which is a contracting party to the convention. In England, it's been held by the Supreme Court that the jurisdiction provisions of the regulation apply whether the other state concerned is a member state or not. And if a similar approach was taken by the Court of Justice of the European Union or in other member states, the jurisdictional provisions of the Convention would be almost redundant within the European Union if the child was habitually resident in a member state. However, if the child is habitually resident in a Convention state, but present in a European Union member state, then the Convention will take precedence. So if the child was habitually resident in Australia, but present in the European Union, then the Convention would apply and Australia would retain jurisdictional primacy. The reciprocal enforcement provisions of the Convention and the cooperation provisions and the applicable law provisions will all remain relevant where one state is a European Union member state and a Convention state, but the other state is just a Convention state. It's also conceivable, because of the slightly different provisions on recognition and enforcement, that an order might fall to be enforced between two European Union member states, but registration could be refused because the Convention was also in effect between those states, and we'll come to that slight difference between the regulation and the Convention later. The 1996 Convention will have effect in all matters which aren't covered by the regulation. That's set out in Article 62. So it's always going to be very important to be aware of which countries are involved, their status in relation to the European Union and the regulation and the Convention, and to be aware of the habitual residence of the child and the precise articles of the regulation or convention that are engaged, because one is going to have to compare the articles in any individual case. Looking at a comparison then between the contents of the regulation and the convention, it's right to say that the European Union recognised the potential benefits of the convention early on, and Brussels II really incorporates much of the convention. It is the child of the convention, as it shares a huge amount of the genetic makeup of the convention. Now I have a helpful table which compares them, which I'll unfortunately won't be able to see. And I'll see if I can show it to the camera. Can we get it to the camera? Not very well, but we'll run through them so that you can see the similarities. Just quickly running through them, and we'll return to some of the points in them. Article 5 of the Convention provides that jurisdiction is to be based on the habitual residence of the child. That is the mirror of Article 8 of the regulation. Article 6 of the Convention provides a jurisdiction based on the presence of the child if habitual residence can't be established. That is the equivalent, the direct equivalent of Article 13. Article 7 provides a retention of jurisdiction in abduction situations. That is the direct equivalent of Article 10 of the regulation. Articles 8 and 9 of the Convention provide for a transfer of jurisdiction in certain cases. Those are the direct equivalents of Article 15 of the regulation. Article 10 of the Convention deals with jurisdiction in relation to children where there are divorce proceedings going on. That is the direct equivalent of Article 12 of the regulation. Article 11 of the Convention allows a court to make urgent temporary measures in relation to a child. That finds its mirror in Article 20 of the regulation. Article 12 of the Convention doesn't have a mirror in the regulation. Article 12 allows a court to take provisional measures in relation to a child who's present on the territory of the state, but where there's no situation of urgency. That doesn't have a mirror in the regulation. Article 13 of the Convention is the lis pendens provision, or the court first seized. That is the equivalent of Article 19 in the regulation. Articles 23, 28 of the Convention are mirrored in Articles 21 through to 47 in the regulation. Articles 29 to 39 of the Convention have their mirror in Articles 53 to 57, although as we'll return to, the cooperation provisions of the Convention are more extensive than those within the regulation, and then there are mirrors in relation to some of the general procedural issues. The obvious differences between them are that the regulation does not have the equivalent of the applicable law provisions of the Convention. Another significant difference, which isn't immediately apparent, is that provisional measures, urgent protective measures, falling under Article 11 of the Convention, are recognised and enforceable in other signatory states. That is different to Article 20 of the regulation. The Court of Justice of the European Union, in the case of Puruca v. Valles Perez, concluded that Article 20 was not a jurisdictional measure, and therefore any orders made or protective measures taken under Article 20 of the regulation were not subject to recognition and enforcement in another member state. And so the Convention provides a useful tool which fills a gap within the coverage of Brussels II, in particular in abduction situations where return orders are made under the 1980 Hague Convention. Protective measures which are accompanying the return order can be subject to recognition and enforcement in the requesting state. Another significant difference is, of course, that the Convention doesn't deal with divorce and separation jurisdiction. The Convention, however, does not have the equivalent of the regulation Article 11, which provides that in abduction situations where a non-return of a child has taken place pursuant to Article 13 of the 1980 Hague Abduction Convention, that the member state of habitual residence can override that non-return using the provisions of Article 11, 6 to 8 and the automatically enforceable certification provisions. The Convention, though, has far more extensive provision for cooperation between states than the regulation does. It's much more explicit in the provisions which deal with that. For instance, it allows a central authority to provide a report on the situation of a child within its jurisdiction. It allows the authorities of state to request its own child protection authorities to take steps to protect a child. It allows the central authority to request the assistance of the authorities of another contracting state to assist in implementing measures, actually taking steps to implement measures. It allows the authorities of a state where a parent is seeking access to a child habitually resident in another state to gather information about the parent in their jurisdiction and to make a finding on the suitability of that parent to have access. And that finding will be admissible in proceedings for access in the other state. It also imposes an obligation in respect of children who are perceived to be in serious danger on the authorities of states to exchange information and to communicate with the authorities of a state where the child may have been taken to allow that state to take protective measures. So those are some fairly significant differences between them. Going back now, though, to some of the differences just within the terms of the articles of the Convention and the regulation itself, as opposed to items which simply aren't covered in one or the other. If one looks at Article 5 of the Convention, Article 8 of the regulation, the jurisdiction based on habitual residence, the Convention is much more explicit in providing for the fact that jurisdiction will obviously shift when the child moves to another state and habitual residence changes. What Article 14 of the Convention does is to make very clear that orders made in one state continue to be valid notwithstanding the move to another state, and that the simple move to another state is not a sufficient change in circumstances on its own to warrant the original order being varied. That's one of the great untested areas in the European Union and under the regulation, is the circumstances in which the court of new habitual residence can properly vary an order made by the original country of habitual residence, particularly an order made at the time of granting permission to relocate to the new state. If that order has access provisions which were carefully considered at the time of granting permission to relocate, in what circumstances can the member state of the new habitual residence interfere? In the Article 7, Article 10 retention of jurisdiction following abduction provisions, they are broadly similar, but of course the Convention does not have the equivalent of Article 11, 6 to 8 of the regulation, that what we call the second bite of the cherry, ability to override a non-return decision in Hague Convention proceedings. And so Article 7 and Article 10 are slightly differently worded to reflect the absence of that that particular provision. Articles 8 and 9 of the Convention, the equivalent of Article 15 in the regulation, so the transfer provisions, Articles 8 and 9 between them provide a forum conveniens route to transfer jurisdiction. The wording of the articles is slightly different. Article 8 of the Convention refers to the court considering whether another court is best placed to assess the best interests of a child, whereas Article 15 of the regulation refers to another court being better placed to hear the case. Article 15 and Articles 8 and 9 are obviously based on assessment of the best interests of the child, and there's an interesting and outstanding issue over the extent to which a court can decline to exercise a jurisdiction conferred on it by either the Convention or the regulation, where the other country concerned is not a European Union member state or a Convention state. In the case of Owusu and Jackson, the Court of Justice of the European Union, in fact I think the ECJ at the time, concluded under the Brussels I regulation in respect of jurisdiction in civil judgments that a court could not decline jurisdiction conferred on it by the Brussels I regulation where the other country concerned with competing jurisdiction was a non-EU member state. Now that's not yet been tested as to whether the same rule applies under the regulation. It's unlikely, I would think, that it does, because the regulation itself, of course, suggests that jurisdiction can be transferred to another state, either by agreement between the parties or by another state being better placed to assess the interests of the child. But it's still yet to be confirmed that in respect of non-member states, the courts of a member state can decline jurisdiction in favour, for instance, of the United States exercising jurisdiction. Article 10 of the Convention, the equivalent of Article 12 of the regulation, deals with prorogation, allowing the parties to choose to litigate over the children in a jurisdiction where the child is not habitually resident. Article 10 of the Convention only permits that where it is in association with a divorce petition or a separation petition. That's mirrored in Article 12 of the regulation, but Article 12 of the regulation goes further in that it permits the parties to opt into a jurisdiction even if there's no associated divorce or separation petition going on. Article 11 of the Convention and Article 20 of the regulation I've already referred to, courts being able to take urgent protective measures in respect of a child present in its jurisdiction but not habitually resident, and that under the Convention those protective measures can be recognised and enforced in another signatory state, whereas measures taken under Article 20 of the regulation cannot be. Article 13 of the Convention, looking at lis pendens, pending actions and courts first seized, the equivalent of Article 19 in the regulation. There's a difference in wording, although perhaps not a difference in substance. Article 19 of the regulation refers to a court staying its proceedings, whereas Article 13 of the Convention refers to it abstaining from taking any steps. And Article 14 of the Convention, it goes to something which is perhaps an omission from the regulation, which and states that orders made in a convention state endure notwithstanding a move to another convention state. As I referred to earlier, it's a big unresolved question as to in what circumstances the courts of a country of a new habitual residence can set aside or vary the terms provided for in the order of another conventional member state. It particularly comes up when enforcement of an order is sought and the responding party says, well, we're now habitually resident here and the court can make different orders. Well, in what context can such orders be varied, or new orders being made which contradict the original order? It may be said that it's self-evident that once a child is habitually resident in another country, the court can do what it wants to, but if that is the case, it may render completely redundant any access orders made by the court of the old habitual residence when granting permission to relocate. So, moving on to the recognition and enforcement provisions, there are slight differences between the convention and the regulation in respect, in particular, of the grounds on which recognition can be refused. In respect of the convention, recognition of an order from another convention state can be refused on the basis that that country did not ever have jurisdiction to make that order, which is completely in contradistinction to the regulation, which specifically provides that the court cannot review the jurisdiction of the court which originally made the order. So that's a whistle-stop tour through the interface between the European regulation, known as Brussels II or Brussels IIR, and the 1996 Child Protection Convention. If you have any queries about this presentation, you of course can contact me. You'll find me at 4 Paper Buildings in London. My email address is dw@4pb.com. I hope this has been useful and thank you for watching.